one. Good afternoon, everybody. I am speaking on behalf of the coordinators, and I'm really happy to see the quality of the teams, all the work done by the arbitrators, by my peers here at the coordination. Everything was so beautiful because there was a large group of people contributing and working along to make all of this happen. We are pretty excited to see the high level of the both teams that will face each other now. And I'll be here waiting to see who's going to win. Some other words to start with. I pass the word to Joaquin. Joaquin, it's with you now.
Hello, it's a big honor to see the 9th edition of Rio Pre Moot. We started 9 years ago as a small moot. We have traditional moots in Rio, like the one in Curitiba, the one in São Paulo. We want to do a little one in Rio. We ended up today with 29 teams from all over the world, more than 200 arbitrators, more than almost 300 students. So that's a big achievement. I couldn't do that without the help of our coordinators and the sponsors. And we have here a very good panel to judge the final. We chose here, it is the Women's Month, and we see in arbitration how women are having a leading role. And it's very significant that we have here three very important and very bright arbitrators, counsel and professors as to judge this. We have Professor Ingeborg Schwenzer, probably the best known and most quoted scholar in CSG. It's a huge honor to have you here, Professor Schwenzer. Also have here Claudia Benavides, head of the dispute practice of Baker McKenzie. She's a partner of Baker McKenzie in Bogotá. And also have Rajid Mariel Elu, co-head of the arbitration practice of Hughes Hobart from the New York office, also licensed in Paris. That's also very significant that we see the leading role of women, not only as arbitrators, but as counsel. We see that from half of, or 3/4 of the finalists are women. That shows the strength, and we are very proud of that. And so now it's time to see who's going to win. But all few that got to the finals already winner. At least we won prizes. We are paying like 1,000 for everyone reais for everyone that gets to the quarterfinals, 2,000 reais to everyone that gets to the semifinals. The second place will win 3,000 reais, and the big winner will win 5,000 reais. So it's up to Professor Schwenzer, it's up to you, Claudia, Rashid, to decide who's the big winner. Thank you all for watching us.
Thank you very much, Joaquin, for this introduction. Good afternoon, good evening, ladies and gentlemen. I hereby open our virtual hearing in the arbitration Respivac PLC against Cambia Limited and Vectorvia Limited. I understand Claimant is represented by Nova School of Law Lisboa, correct? And Respondent is represented by the Federal University of Bahia, correct? Thank you. To my two co-arbitrators, counsel for both parties have informed me that they discussed how they want to structure this hearing. Respondent wants to go first on procedure, then followed by Claimant. And on the merits, Claimant would go first, followed by Respondent. Each counsel wants to plead for 14 minutes, followed by rebuttal and surrebuttal of 1 minute respectively. I wanted to ask my two co-arbitrators whether this procedure is all right with them.
Yes, thank you, Professor Schwenzer.
Thank you.
Yes.
Then we may start, and I give the floor to counsel for respondent on the procedural matters, please.
Thank you. Members of the Arbitral Tribunal, counsels for claimant, good afternoon. My name is Milena Prestes, and I will represent the respondents in the procedural issues of the case Respivec versus Camvir and Vectorvir. Members of the Arbitral Tribunal, 2020 led us through a reality that none of us could imagine: a world pandemic, an economic crisis, a restructuring of all that was familiar and known. On the one hand, this allows us to see the trust in which business relations are built. On the other, it created the perfect excuse for former trusting partners, such as claimant, to both demand advantages through allegations of nonconformity and to request that we do not even include the one party that could put an end to these concerns. In light of this, I will structure my speech in two parts. First, I will explain why Ross Pharmaceuticals should be joined into this arbitration, and second, why the second hearing should not be remotely conducted. In relation to the first submission, we should highlight that the request for the joinder is in relation to the arbitration agreement. At no point have respondents tried to bind Ross to the contractual obligations of between respondent number 1 and claimant under the purchase, collaboration, and licensing agreement, which I'll further refer as PCLA. That being said, as a premise, the arguments here are disposed considering the separability of the arbitration agreement and therefore are arguments under applicable procedural framework. When concluding the PCLA, the parties agree that any dispute arising out of the contract would be resolved by arbitration in accordance with the Swiss rules. In this regard, the parties agree to the Swiss rules joinder provisions laid down in Article 4.2. And for there to be a joinder under this article, the tribunal is required to take into account all relevant circumstances. Considering that this provision is indeed fairly broad, it does depend on the particular situation and arbitral tribunal. But as a frame of reference—
Counsel, may I shortly interrupt you? Does this tribunal have jurisdiction over Ross?
Madam Presiding Arbitrator, the first consideration made by a commentator of the Swiss rules named Philippe Guillahillon from University of Lausanne is regarding the jurisdiction of the arbitral tribunal under Article 4.2. Here, the tribunal has jurisdiction over Ross Pharmaceuticals since we have two arbitration agreements that are identical, the one between respondent number 1 and claimant, and the other between respondent number 2 and Ross Pharmaceuticals. And under the Swiss rules, it is already sufficient to establish the jurisdiction, since it means that all the parties and Ross Pharmaceuticals agreed priorly to be joined into pending proceedings or to have third person joined into arbitration proceedings. And this is why, in our case, the tribunal has jurisdiction over Ross Pharmaceuticals. A second—
Counsel, is it your position that anyone who enters into an arbitration agreement under the Swiss rules has given its consent to a joinder in any other arbitration under the Swiss rules? Is that your position?
Madam Presiding Arbitrator, respondent's position is that when the parties consent to arbitrate with the Swiss rules, they are consented, yes, to be in arbitration proceedings and to be joined into arbitration proceedings. Of course, it is not every person that could be joined. The tribunal shall take into account the relevant circumstances of the case.
Okay, but in principle, it is consent. Thus, any tribunal acting under the Swiss rules has jurisdiction over any third party who agreed to the Swiss rules. And then we have discretion whether we want to join that third party or not. But jurisdiction is given in any case, you said.
Yes, if there is an identical arbitration agreement binding one of the parties to the arbitration and the third person, Madam Presiding Arbitrator. And this is precisely the situation in our case, where there is an arbitration agreement.
Where do you get that criterion from, whether there has to be an identical arbitration agreement? Where's
Madam
that? Where can I find that?
Madam Presiding Arbitrator, this is provided by commentators to the Swiss rules, according with, for example, Professor Philippe Gillion, Dorrit Schramm, and also Richard Bamford and Angelina Mading. And considering that the provision of Article 4.2 is indeed fairly broad, we need to assess those commentators to acknowledge what it means relevant circumstances. And for these commentators, other two relevant circumstances must be taken into account, despite the fact that the two arbitration agreements exist. The first one is regarding the link between the claims, the link between the claim of the pending proceedings and the claim made against the third person. And we should highlight here that Claimant initiated this arbitration due to Ross Pharmaceuticals' allegations that he holds an exclusive license for the field of respiratory diseases, which in turn could influence in Claimant's license. And with that in mind, I kindly ask the tribunal to follow me to the page 8 of the case file.
Counsel, may I just ask a question? The existence of identical arbitration clauses, is that in your view a precondition for joinder, or is that one of the discretionary elements that the tribunal must take into account?
Madam Arbitrator, it is a relevant circumstance that the tribunal may take into account, but it's sufficient to establish the jurisdiction. But the jurisdiction is not the only thing that the tribunal should consider. And if can you please let me know if you're in the page 8, please. Members of the tribunal, this is the notice of arbitration. And here in paragraph 26, we read, in the present case, the use of the Gored-Chem vectors may, however, be potentially restricted by an IP right of Ross Pharmaceuticals. And in paragraph 28, we read the rationale behind Claimant's concerns. Here, members of the tribunal, in the second line, and I quote, certainty concerning unrestricted ability to use the virus delivered is of crucial importance. Now, this certainty that Claimant seeks is essentially related to the claim made by respondents against Ross Pharmaceuticals. In the answer to the notice of arbitration, respondents expressly request the tribunal not only to allow the joinder of Ross Pharmaceuticals, but to make Ross Pharmaceuticals to stop with any other allegations. And this is why we need to have Ross into these proceedings, so the arbitral award.
But is it your position, counsel, that we have to, when we come to the merits of the case, that we have to decide whether indeed Ross holds an intellectual property right? Or isn't that irrelevant under Article 42? Isn't it enough if Ross asserts a claim but does not have an underlying right? So why should we decide whether Ross actually has a right under the contract with the respondent too?
Madam Presiding Arbitrator, the necessary joinder, the necessity of the joinder of Ross is not to assert if there was a violation of Article 42 or not. We acknowledge that claim it is sufficient and we cannot assert the scope of the Ross agreement precisely, but we should highlight here that Claimant's claim to assert if there was a violation of the contract is essentially related to the allegations made by respondents, to the allegations made by Ross Pharmaceuticals regarding its exclusive license. And the only way the tribunal can resolve the issue in a comprehensively and conclusively manner between all those involved is to have Ross here and bound Ross Pharmaceuticals to the arbitral award. And this is why we ask Ross to join these arbitration proceedings, to guarantee the certainty that Claimant seeks and to resolve this issue once and for all. Now, in the event Ross joins this arbitration, respondents will have to present evidence to prove that the exclusive license granted to Ross indeed does not encompass respiratory diseases. And for this purpose, the second hearing has been scheduled to occur. What leads me to the second issue, that the second hearing should not be remotely conducted. Members of the tribunal, in the light of the pandemic, the main argument for having a remote hearing at this moment is the pressure of time. But even this line of argumentation cannot be sustained. On the one hand, Claimant opposed the joinder of Ross Pharmaceuticals, which would ultimately speed up how we resolve the problem regarding the allegations of Ross and its exclusive license. But on the other, ask that we have remote hearings because time may be of the essence. However, truth of the matter is that Claimant is not being prevented from producing its vaccines normally. But what will most certainly occur with a remote hearing is that while trying to resolve a complex issue, members of the tribunal, we could have a compromising assessment of evidence, especially if we consider that the time difference of the parties is 11 hours. With this in mind, I would like to highlight the teachings of Professor Kaufman-Kohler and Thomas Schultz when they affirm that remote hearings are only truly effective and can replace in-person hearings when the level of details and discussion does not matter that much.
But counsel, when did she write that article? Was that during the pandemic or was that well before the pandemic? Because I think really everything changed now during the time of pandemics and we are having virtual hearings everywhere.
Indeed, Madam Presiding Arbitrator, everything is changed. And this article was not written at the pandemic, but in this regard, we would like to draw this tribunal's attention to a survey conducted by Professor Gary Bourne in last year, where the pandemic was already occurring. And the result, members of the tribunal, was that the remote hearings were not effective as in-person hearings. In that survey, it was asserted that experts themselves considered that the remote presentation of the evidence impaired the tribunal's assessment over it. And the reason behind this is that not only that the attention span is compromised and it is more difficult to assess the body language and nonverbal cues, but also a lot of failures can occur. For example, the people cannot be able to join the platform or having poor internet connection. And this is why in cases where highly complex evidence is going to be presented, such as in our case, remote hearings are not very effective. We should highlight that the purpose of the second hearing is to dive into details about the use of a viral vector.
What is the highly complex evidence you are seeking to rely upon?
Madam Presiding Arbitrator, the content of the second hearing is going to be the discussion surrounding the scope of the Ross Agreement. And therefore, we will be diving into explanations regarding the use of the GORAD-CAM viral vectors, their ways of production, the difference between the various applications of the virus, to assert that Ross Pharmaceuticals does not have an IP right to develop vaccines on the field of respiratory diseases using the GORAD-CAM viral vectors. And this is why the evidence is highly complex. And this issue is even aggravated when we consider the time zones of the parties. This means that we could have sessions.
Can I ask you a question about the time zones? Because if one wants to conduct an in-person hearing, presumably the witnesses would be coming from other time zones and would have to acclimate to the change in time zone. So how is that different in this circumstance where fine, they're not traveling, but nonetheless in an actual hearing would be expected to acclimate to the time zone?
Because in in-person hearings, all the participants will be gathered in reasonable hours and not as in remote hearings, we could have sessions, for example, in the middle of the night or in the early morning for one or other participants. And this is what respondents are trying to avoid. And for all these reasons,
yes. Yeah, counsel, you mentioned early in the morning. If claimant were to suggest that they start at 5 o'clock in the morning, it's claimant's choice, isn't it?
This would not be
accommodate with the situation of respondent.
I see that my time has already elapsed. I ask just 30 seconds to answer your question.
Yes, please, sure.
Thank you. Madam Presiding Arbitrator, this would not be able to occur since one of the arbitrators is based where claimant is based. So we need to assert that all participants, not only the counsels, but the arbitrators were supposed to be gathered in reasonable hours. And this cannot occur by a time difference of 11 hours. And therefore, respondents end their submissions. Thank you.
Thank you very much, counsel. And do my two co-arbitrators have questions for counsel for respondent? If this is not the case, then thank you, counsel. Then we move on to counsel for claimant. The floor is yours, please.
Thank you, Madam Presiding Arbitrator. Honorable members of the tribunal, opposing counsels, good afternoon. My name is Ana Souza, and along with my co-counsel, Martim Mimoso, we'll be pleading on claimant's behalf, Respivac PLC. I'll address the procedural matters, and I'll give the floor to my co-counsel to defend the merits of the case. Members of the tribunal, mutual trust and commitment honoring are the foundations of commercial contracts. However, we are here today due to respondents' complete disregard for these principles. Respondents are attempting to shift the tribunal's attention by requesting an unnecessary joinder of a direct competitor of claimant, and are denying claimant justice by refusing to hold the hearings virtually. Therefore, and mirroring opposing counsel structure, I'll be making two submissions. The first, that Ross Pharmaceuticals should not be joined to these proceedings, and the second, that the hearing must be held fully remotely. Turning to my first submission, Ross Pharmaceuticals should not be joined to these proceedings. We'll first argue that, with all due respect, the tribunal does not have jurisdiction over the conflict between Ross Pharmaceuticals and respondent number 2. And second, even if the tribunal would be empowered to do so, the joinder should be refused when considering the circumstance of the case. Members of the tribunal, what opposing counsel failed to address is that Article 4.2 of the Swiss rules only gives the procedural framework from which the tribunal may decide a joinder, but it does not create a jurisdictional basis. The jurisdiction of the tribunal arises out of the parties' agreement to arbitrate between themselves. And in the present case, not only there is no arbitration agreement between claimant and Ross Pharmaceuticals, but far worse, both claimant and Ross Pharmaceuticals are expressly objecting the joinder. And as Article 4.2 of the Swiss rules cannot be seen as a disregard of consent, and neither claimant or Ross Pharmaceuticals have implicitly consented to the joinder, the tribunal does not have jurisdiction.
Counsel, I have a question. Both arbitration agreements provide for appointment of the arbitrators by the institution, correct?
Yes, Madam Presiding Arbitrator.
Isn't that a sign or the very forecast that there might be a third party joined who then cannot appoint its own arbitrator? So didn't have the parties have that in mind when agreeing on an appointment by the institution?
Madam Presiding Arbitrator, as I was going to further explain, in the present case, because claimant was not aware of the dispute between Ross Pharmaceuticals and respondent number 2, he could not predict this joinder. And therefore, at the time of the acceptance of the rules, he could not have implicitly consented to the joinder. And even if the situation of the arbitral institution is going to appoint the arbitrators in the present case, that is not reason alone for claimant or Ross Pharmaceuticals to have predict this particular joinder. And if I have addressed your question, if we were to follow respondent's reasoning, as Madam Presiding Arbitrator also highlighted, claimant and Ross Pharmaceuticals' acceptance of the Swiss rules would to be seen as a carte blanche to any possible joinder. However, according to Professor Gary Bourne on the commentary on Article 4.2, agreeing with the Swiss rules does not constitute sufficient consent to the joinder. And thus, given that Ross Pharmaceuticals did not implicitly or expressly consented to the joinder, this tribunal does not have jurisdiction over this third person. Members of the tribunal, compelling a non-signatory of the arbitration agreement upon which the jurisdiction of the tribunal is based violates the fundamental principle of parties' autonomy, and decisions such as this one can move arbitration to a direction closer to the state court's compelling nature.
Can you elaborate on the role that efficiency concerns should play here in considering the relevant circumstances?
Yes, of course, Madam Arbitrator. The efficiency of the proceedings is indeed one of the circumstances that the tribunal has to bear in mind. And in the present case, contrary to what opposing counsel stated, it would not be efficient to join Ross Pharmaceuticals in the present proceedings. The joinder of Ross Pharmaceuticals is unnecessary, and therefore we would only be joining a third person, and therefore making these proceedings a much more complex arbitration. If I can just step a little bit back on the jurisdictional theme, I would also like to highlight to this tribunal that opposing counsel argumentation is based only that the arbitration agreements are similar. However, even in such cases, according to Professor Andrea Mayer, the tribunal has to analyze if the parties had a common intention to submit the whole dispute to the same tribunal. And as I stated before, claimant had no intention, as it only became aware of the dispute between Ross Pharmaceuticals and respondent number 2 after the signing of the arbitration agreement. Now turning to my second argument, even if the tribunal finds that it has jurisdiction, the joinder should not be ordered, given that the circumstance of the case call for its refusal. Respondents want to join Ross Pharmaceuticals with the sole intention of solving their personal dispute, and such reason alone cannot be seen as a legitimate interest. The questions that will be discussed in these proceedings do not require the presence of Ross Pharmaceuticals, as under Article 42 of the CISG, the mere existence of a claim is sufficient for the breach of contract to be declared. And therefore, following the decision of the Superinvestment versus Argo Investment Bank, the joinder should be refused, since the tribunal is able to assess whether respondents have failed to perform their obligations in the absence of Ross Pharmaceuticals. Also, regarding the confidentiality of the proceedings, which is another circumstance that the tribunal must take into account, it would be jeopardized with the joinder of Ross Pharmaceuticals. Joining a direct competitor of Claimant is allowing this company full access to crucial data and regarding the method and the status of Claimant's vaccine, and therefore the joinder should be refused. Lastly, I would like to point out to this tribunal that the joinder would create a risk for the set-aside or non-recognition of the award under Article 51C of the New York Convention, since the Ross Agreement is not covered by the arbitration agreement, and therefore, if the tribunal renders an award in regards to the scope of that contract, it will be deciding beyond the submission to arbitration and consequently undermining the integrity of the award. Therefore, Ross Pharmaceuticals should not be joined to these proceedings. And if the tribunal does not have any further questions, I conclude my first issue. Moving on to my second submission, the hearing must be held fully remotely. On what concerns this issue, claimant will demonstrate firstly that the tribunal does have the necessary power to rule on a remote hearing, and secondly, that the proposed hearing format is the best decision to the present proceedings, contrary to what opposing counsel has stated. The tribunal has the power to rule on a remote hearing. The choice of the hearing format falls within the tribunal's discretion, pursuant to Article 15.1 of the Swiss rules, given that the parties' agreement and the due process principles would not be violated if a remote hearing is to be held. If the tribunal kindly joins me on page 16 of the records, in clause 14.1 to be precise, and if the tribunal could give me a nod when it's thank you. In the third paragraph, second phrase, it says, and I quote, "Hearing shall be held at the tribunal's discretion, either in Vindobona or in the city where respondent has its place of business." It is clear that parties decided to add this provision to the Sky Model Clause in order to hold hearings in case of a dispute.
And counsel, this was not the point your opposing counsel was relying upon. Opposing counsel was relying on efficiency questions for the hearing and was relying on questions of time zones and of organizing such a hearing.
Indeed, Madam Presiding Arbitrator, I would just like to point out to the tribunal that it indeed has the power to rule on a remote hearing, if that is one of the tribunal's questions. But if it not, I can now proceed to my second argument that will address those concerns. A remote hearing is indeed the best decision to the present proceedings, since according to the balancing exercise that Professor Maxi Scherer proposes, the benefits of a remote hearing outweigh the risks by far. Opposing counsel has stated that there is no problem regarding the pressure of time. And indeed, claimant is seeking for certainty, and therefore all participants, according to Article 15.7 of the Swiss rules, have the obligation to contribute for an expeditious award, which is not what respondents are doing in the present proceedings. And therefore, it is indeed important that this tribunal renders an award efficiently so that claimant can have the legal certainty that is seeking for. Regarding the assessment of the witness credibility, which the opposing counsel has stated and may lead this tribunal to believe that the party's right to present their case can be jeopardized. Opposing counsel has stated that in these proceedings, there are complex issues that need to be resolved, which is indeed true. We are here to talk about a viral vector, which can be complex. However, one thing that opposing counsel failed to mention is that the tribunal has an expertise on IP law and on development of vaccines, according to what is stated in the arbitration agreement that the parties drafted. And therefore, for this tribunal will be easily understandable the question of the viral vector. And it is not a remote hearing that will actually jeopardize that situation. Also, regarding the possible technical difficulties that opposing counsel also brought, that is a question that cannot be actually, it should be dispelled by this tribunal. I'm sorry. Indeed, the Austrian Federal Court already stated in the Sino Dragon versus Noble Resources case that even in the unlikely scenario in which technical difficulties may arise, and in the present case, it is unlikely because the parties have the capacity in terms of bandwidth and equipment to have the hearings conducted remotely, the court has decided that the parties' right to present their case will not be jeopardized by those technical difficulties. Also, regarding the issue of time zones, I would like to point out to this tribunal that the Austrian Supreme Court on July of 2020 has already stated that this should not be overemphasized, the problem of time zones, especially because, as it was pointed out by Madam Arbitrator, if the parties would have to travel, and this was actually said by the tribunal, the harm on the participants' routine would actually be much higher than to simply have the hearing conducted remotely. And also, when the parties have selected an arbitral institution based in Europe, they are also accepting the geographical distance and the consequences, and therefore the time zone differences. Even so,
Counsel,
excuse me, may I?
What is your suggestion? What time frames should we consider when for the hearing?
Yes, Madam Presiding Arbitrator, I was just coming to that precise point. The time zone issue is easily resolved. A reasonable hour to hold the hearings can be arranged, and claimant is willing to select a schedule that is more beneficial to respondents. For example, if a hearing is to be held at 11 a.m. Danubian time, it would correspond to 8 a.m. in Mediterranean and 7 p.m. in Equatoriana. And since I'm aware that I'm running out of time, if I could just have one more minute to conclude my issue.
Yes, please, go ahead.
And since I'm aware that I've addressed the issue of the time zone, and just to conclude this aspect, I would also like to point out to this tribunal's attention that in page 44 of the records, on the top right of the page, we see that not only the participants are in these venues, but also the arbitrators are located in Danubia, Mediterranean, and Equatoriana, and therefore the hours that I've just proposed are also suitable for the arbitral tribunal. Now, coming to my last point, the witness credibility is indeed a concern, but only if in-person hearings are to be held, given that due to the public health concerns, the participants would have to wear masks and maintain a considerable distance between themselves, while a screen would allow a closer look on the witness face. And with this, I ask the tribunal to refuse the joinder of Roche Pharmaceuticals and to hold the hearings virtually. Thank you.
Thank you very much, counsel. Do my two co-arbitrators have any questions?
Nothing further.
Thank you. Then I give the floor to counsel for respondent. You have the possibility to rebut these arguments.
Thank you. Members of the tribunal, claimant is the one insisting in having remote hearings, but in the case file, claimant already stated that it does not have a need to hear any expert or witnesses. Rather, the second hearing would be respondent's means to explain and prove their case to the tribunal. And if the hearing is not effective or is compromised in any way, respondents are the one being obliged to prove their procedural rights at risk, while, as opposing counsel mentioned, claimant would continue to develop its vaccines normally. Thank you.
Thank you very much, counsel for claimant. Anything on the rebuttal?
Yes. Honorable members of the tribunal, claimant is submitting for a remote hearing because the time is a question that it's very important on the present case. We are here discussing a vaccine that it's much needed for the entire world. And for claimant to have legal certainty on such product, the hearings have to be held remotely. Regarding the examination that respondent is so concerned is also to highlight that the cross-examination will lie on claimant's side because the respondents are the one that want to examine experts and witnesses. And therefore, there will be no problem regarding the credibility or the assessment of such credibility. Thank you.
Thank you very much, counsel. Any questions from my two co-arbitrators on procedural issues?
Yeah, just a quick question, if I may, Professor. Because I had a technical issue actually at the very end of the claimant's presentation, but could you please elaborate a little bit on whether the right to equal treatment of both parties would be somehow impacted or affected by the fact that the hearings are conducted remotely?
Madam Arbitrator, regarding parties' right to equal treatment, that would also not be violated on the present case, because as it's stated in the procedural order number 2, both parties have the capacity and the equipment to have the hearings conducted remotely, which must suffice. And therefore, it's not only because claimant may have better technical equipment that such right would be violated. Thank you.
Thank you very much, counsel. If there are no further questions, then we move on to the merits of the case. And counsel for claimant, please, would you like to start on the merits of the case?
Madam Presiding Arbitrator, may I just confirm that the tribunal is hearing me correctly? Yes, thank you very much. Pristine members of this tribunal, opposing counsels, good afternoon. My name is Martim Mimoso, and I'll address the substantive issues raised before this tribunal on behalf of claimants. The COVID-19 pandemic has costed millions of lives, and our hopes lie on companies like Claimant, as on 2019, it celebrated an agreement with respondent number 1 involving the sale, collaboration, and license over the Goracam vector, a base material with great potential for an effective vaccine. However, it subsequently turned out that in 2014, respondent number 2 granted an exclusive license regarding the same viral vector to a direct competitor of Claimant. Consequently, the development of a vaccine by Claimant is put at risk. In this sense, Claimant has two main submissions. Firstly, The agreement celebrated between claimant and respondent number one is governed by the CISG. And secondly, respondent number one has breached its obligations to deliver goods free from third-party intellectual property claims under Article 42 CISG. Starting with the applicability of the convention to the agreement, which I will refer as PCLA. Article 3.2 CISG states that, and I quote, "This convention does not apply to contracts in which the preponderant part of the obligations of the party who furnishes the goods consists in the supply of labor or other services." Under the PCLA, respondent number one was obliged to deliver goods, but also to grant access to licensed technology as well as the collaborative activities. Madam Presiding, do I sense a concern?
Thank you, Counsel. I'm very much interested in the interests of the parties. So not just in theoretically applying this law or another law. What are the interests of your client that we apply the CISG?
Madam Presiding Arbitrator, the CISG has a specific rule, which is Article 42 CISG, that protects the buyer against buying goods which are encumbered by third-party intellectual property claims.
So it is your position, if we were to apply domestic law, the buyer would be unprotected?
In any, Madam Presiding Arbitrator, the buyer, in this case, claimant, would have protection. However, the protection that it's granted by the CISG has a higher level of protection, and therefore,
I always thought it's lower because the countries in which the seller has to guarantee freedom of intellectual property rights are extremely restricted territorially. I always thought it's narrower, the liability under Article 42 CISG than under domestic legal systems.
In any case, Madam Presiding Arbitrator, we are talking about a vaccine, a good which is meant to be used in a worldwide context. And furthermore, both claimant and respondent number one were respondent number one was aware of the RESPIVAC of the Ross Agreement contract, and therefore such territorial limitation should not be applied in the present case, since the license that was granted to claimant has a worldwide scope. And therefore, the protection that is granted by Article 42 CISG should have the same reach as well. As I was previously stating, and according to Professor Schwender herself, both granting access to licensed technology as well as the collaborative activities are to be considered services obligations under Article 3.2 CISG. In this sense, the Advisory Council states that to evaluate the preponderant part of the obligations of the party, the tribunal has to resort to one of two different criterions, an economic criterion or an essentiality criterion. Madam Presiding Arbitrator.
Yes, I'm still at some level before that. I have been asking myself whether this is truly one contract or whether we are facing two contracts. One that goes from Article 1 through Article 15, and the other one, which is a future contract, a conditional contract, Article 16. Shouldn't we look at it as being two contracts, or why are you arguing this is only one contract?
Madam Presiding Arbitrator, the problem of the agreement being one or separate contracts is a matter of contract interpretation. And in the present case, if the tribunal could join me on page 17 of the records, we can see, if the tribunal is with me, and if the tribunal is with me, I'm sorry, we can see on the bottom of the page the signatures of both the CEO of Camvir and RESPIVAC. And furthermore, if the tribunal could join me on clause 15.3, we can see that there is an entire agreement clause. And therefore, the tribunal has no other option to conclude that the agreement is indeed a single agreement. As I was previously stating, and according to the intention of the parties, the tribunal has to conclude that respondent's number one preponderant part of its obligations did not consist in providing additional services for the following reasons. Firstly, I would kindly ask this tribunal to join me on page 11 of the records, which is the first page of the PCLA. Under the recitals part of the agreement, and if the tribunal is with me, respondent number 1 declared, and I quote, that it is a contract manufacturer organization that produces and sells base materials for the production of innovative treatments and vaccines, end of quote. Thus, this is the fundamental premise upon which the agreement that we have in front of us must be interpreted. Respondent number 1 dedicates itself to the manufacturer and sales business and not providing additional services. Secondly, the drafting history cannot be ignored. The agreement that we have in front of us was the end result of a negotiation which was based upon a collaboration agreement. However, there are key differences. The new name of the agreement, which according to the hotels materials case is one important aspect to evaluate the intention of the parties, was changed from collaboration agreement to purchase, collaboration, and license agreement. Furthermore, parties added a whole new section, Section 16 of the contract headed Purchase Obligations for Vaccine Production. And in fact, Section 16 of the contract was so important to respondent number 1 that it made sure to include them in all of its future contracts. Therefore, both these two elements, the name of the agreement and the addition of Section 16, demonstrate the importance of the sales obligations in the eyes of both parties. Lastly, it is true that without the license, claimant would not have been able to conduct any research at all. However, the exact opposite is also true. If claimant solely received the license without any type of corporeal goods, claimant would not have been able to develop any vaccine at all. Therefore, the tribunal can conclude that both the sales and non-sales obligations of the contract are equally important, forming a symbiotic relationship. Hence, we cannot distinguish which one is preponderant over the other. And following the indubio pro conventione principle, the tribunal should favor the application of the CISG to the contract. And with this, claimant finishes its first issue and moves to his second one, under which claimant has two main arguments. Ross's pharmaceutical dispute constitutes a third-party intellectual property claim for the purposes of Article 42, and respondents were aware of said claim. Article 42.1 CISG refers that a seller, Madam Presiding Arbitrator.
Yes, I'm lagging behind a bit because you did not mention it. Which law should we consider when determining whether Ross has indeed a claim against your client? Or whether Ross has a claim. So which law does govern the relationship between Ross and your client?
Madam Presiding Arbitrator, it would be the Danubian contract law, because Ross Pharmaceutical would have to raise a claim within the country where claimant is seated. And in any case, the tribunal cannot forget that the license is to be used in a world.
But claimant is not seated in Danubia, is he?
No, Madam Presiding Arbitrator, I made a small mistake. You're correct. Claimant is seated in Mediterranean.
So we should look at Mediterranean law?
Indeed, Madam
So
Arbitrator.
you know whether the claim by Ross is founded because it is your law, isn't it?
Indeed, Madam Arbitrator.
You have been raised in this law and studied it there. So tell us, is the claim by Ross under your law, under Mediterranean law? Is it founded or not?
Madam Presiding Arbitrator, the tribunal has to consider the wording of Article 42 CISG, which uses the term, the seller must deliver goods which are free from any right or claim. And the rationale that was adopted by the Austrian Supreme Court was that even if the claim is found frivolous, the seller should bear the responsibility of the delivering goods encumbered by such claim. And furthermore, according to Professor Schwenzer herself, the buyer is under no duty to investigate because it will be unaware of the nature and specificities associated with the goods. But even if the tribunal does not agree that we are standing before a frivolous claim, the tribunal cannot disregard two specific and very relevant aspects of the case. Respondent number 2 cannot reasonably expect that the broadening of the scope of the Ross agreement that was made against a payment of 600,000 euros, 20% of the value of the Ross agreement, to include related infectious diseases did not cover COVID-19. And on the other hand, the length of the dispute, Ross's pharmaceutical predisposition to mediate the problem, and the subsequent offers made to settle are inconsistent with the classification of a frivolous claim. Moving to my second argument, Article 42 CISG also refers that it must be determined that the seller knew or could not have been unaware of the third-party intellectual property claim. And respondent number 1 knew and could not have been unaware of the third-party intellectual property claim for 2 fundamental reasons. Firstly, Peter Doherty was respondent number 2 legal director, and in December 2018, it had a direct participation on the negotiation process of the PCLA on behalf of respondent number 1. Moreover, during such negotiation process, Peter Doherty was contacted by Ross Pharmaceuticals in an email where Ross Pharmaceuticals clearly states that it could use the Agoracam vector in the context of respiratory diseases, which include COVID-19. Secondly, on the date of the signing of the PCLA, Peter Doherty started to work with respondent number 1. Therefore, either through the direct involvement on the negotiation process or by employing Peter Doherty, respondent number 1 actively knew about the existence of the dispute. Article 42(2)A CISG states that the respondent's liability is only excluded if at the time of the conclusion of the contract, the buyer knew or could not have been unaware of the right or claim. And claimant could not have been unaware of the intellectual property right of the intellectual property claim for 2 different reasons. Firstly, as I was previously explained, according to Professor Schwenzer herself, the buyer is under no duty to investigate. And furthermore, claimant CE...
Counsel, it's not a question of investigation. It's a question of mere counseling your client. I mean, you must know the law of Mediterraneo and thus know whether Ross has a claim under the law of Mediterraneo or not. Because Ross is not the holder of the patent, is Ross?
I'm sorry, Madam Presiding Arbitrator.
Who is the patent holder?
It is not Ross. However, the fact was that the claim was raised between respondent number 2 and Ross Pharmaceuticals in closed encounters. And it was published in the news article, which claimant could not have any access because in January 2018, the CEO of company terminated its subscription to the Biopharma Science Journal. And lastly, at the time of the publication of such article, claimant already had access to the previous PCLA template, which contemplated not only a good faith clause, but also the representations and warranties section. And therefore, by knowing such template, claimants' any possible doubts would have been dispelled by such 2 specific clauses. And with this, claimant finishes its argument, asking this tribunal to declare that under the CISG, respondents have breached their obligations to deliver goods free from third-party intellectual property claims. Thank you very much.
Thank you very much, counsel. My 2 co-arbitrators, do you have any questions on the merits?
Thank you. Yeah, I would have a quick question. Would you please elaborate a bit more on what would impact on the overall Respivac Goradam-Cam viral vectors being purchased by Respivac?
I'm sorry, Madam Arbitrator, I had some connection problems. May you repeat your question? I'm sorry.
Sure. And it's probably me, the responsible one for the technical issues. So no, I was just wondering, in terms of the impact that it would have to the overall contract, if at the end of the day there was no initial batch of the viral vectors being purchased by Respivac, what would be the effect and the overall impact on the contract if that were to happen?
Madam Arbitrator, in order to conduct any research, claimant needed access to the first batch of Goradam vectors. And therefore, without such sale, claimant would be deprived to develop the vaccine, which was the purpose of the agreement. Therefore, if such first batch was not delivered, claimant would be deprived to reach the agreement's goal.
Thank you.
Any further questions? Okay. If there are no further questions, Claudia, no further questions or?
No, thank you. Thank you, Professor.
Thank you very much. Then we turn to counsel for respondent. Please, the floor is yours.
Good afternoon and good evening, members of the tribunal, opposing counsels. My name is Ana Luisa Castro, and I'm here to represent the interests of the respondents on the merits of the case. Members of the tribunal, claimant has presented its own version of the facts. Allow me to show you the other side of the story. I will now address the points raised by opposing counsel in the order they were presented. We will argue that, first, the CISG is not the governing law of the purchase, collaboration, and licensing agreement hereinafter PCLA concluded between claimant and respondent number 1, and second, that respondent number 1 did not breach its contractual obligations to deliver conforming goods pursuant to Article 42 of the CISG. On the first submission, concerning the application of the CISG to the contract concluded between the parties, opposing counsel submitted that the PCLA constitutes a contract of a mixed nature, of
Yes.
which...
Counsel, please, may I interrupt you? You heard my question to counsel for claimant. Why is it so important which law to apply? I want to ask you the same question. Why is your counsel opposed to applying the CISG and wants domestic law to be applied instead?
Madam Presiding Arbitrator, respondent submits that the contract falls outside the material scope of application of the CISG, and consequently, the substantive...
Okay, that's a very nice theoretical question, but what is your client hoping? Obviously, your client hopes not to be held liable. So what is the difference between Article 42 and the otherwise applicable domestic law? Why could your client be held liable under Article 42 and not under the otherwise applicable domestic law?
Madam Presiding Arbitrator, the domestic law of the Nubius is a verbatim adoption of the unidroit principle and has no provision that relates to Article 42 of the CISG in regards to a violation of delivering non-conforming goods by that are not free from third-party claims. But this is not the main argument why responding is opposing to the application of the CISG, but rather that the material scope of the convention does not cover contracts of which the proponent obligation consists in the sale of goods. And in the present situation, the contract concluded between claimant and respondent number 1 is not of a preponderant part of sales. Opposing counsel mentioned the CISG's advisory council opinion number 4.
May I just ask a clarification question? You said the sales part is not the preponderant part. Is that correct?
Precisely, Madam Presiding Arbitrator.
But as I read Article 3, Para 2 of the CISG, this is not what Article 3, Para 2 says, does it? It says the convention does not apply if the preponderant part of the obligation consists in the supply of labor or other services. It does not say the convention applies if the preponderant part is the sales part, but it says it does not apply if the services part is the preponderant part. Is there any different, or can we just say, okay, we have a look whether the sales part is the preponderant part and then we apply the CISG? So does it make a difference?
The presiding arbitrator, as recognized by opposing counsel, licensing agreement falls under the scope of services and other obligations, and thus, in the present situation...
Yeah, but that was not my question. My question to you was, you said if the sales part is the preponderant part, we can apply the CISG. And I say, well, that's not the wording of Article 3.2.
Madam Presiding Arbitrator, I apologize if I did not understood your question correctly in the first time. However, according to commentators, as for example, Peter Huber, the Article 3, Paragraph 2 of the CISG provides a broad interpretation that services and other elements covers
all obligations that relates to a non-sales aspect. And in the present situation, contrary to opposing counsel's submissions, the proponent part of our agreement was not of a sales nature. Initially, opposing counsel led this tribunal's attention to the recitals part of our agreement, in which it is stated that respondent is a contracting manufacturing organization. However, opposing counsel failed to observe that according to Article 1, Paragraph 3 of the CSG, the commercial character of the parties cannot be taken into account to determine the scope of application of the convention. And also, opposing counsel mentioned that the essentiality criterion in the present situation was, and it was stated, and I quote, that we could not determine the proponent part of the agreement since the licensing and the goods are equally important to the present situation.
Counsel, you heard my question that I was asking opposing counsel, whether we should regard this contract as one single contract or rather consider whether that might be two contracts. So what is your point on this question?
Madam Presiding Arbitrator, as highlighted by opposing counsel, our contract has an entire agreement clause. Consequently, we can assume that all obligations under the contract are constitutes obligations of the same contract. But even if we consider the inclusion of our clause 16 of the contract to our agreement, this is not also the proponent obligation.
But you concede that it is one contract.
Yes, Madam Presiding Arbitrator, for the sake of responsiveness, respondent concedes in this submission. However, according to the intention of the parties and the essentiality criterion, the proponent part of our agreement was the licensing aspects. For instance, in the cylinder case decided by the District Court of Mainz, the tribunal decided that the words and the emphasis added to certain contractual obligations could be used to determine the essential part of an agreement. And members of the tribunal, in the present situation, only one clause in the entire agreement relates to a conditional obligation to purchase goods. I would like to please draw this tribunal's attention to page number 12 of the record. Here, members of the tribunal, on the clause number 2, we can see the scope of the agreement. And the scope reads, and I quote, that this agreement governs the terms and conditions of the collaborative activities with respect to the GORD-CAN vectors for the indications of infections and non-infectious diseases. We can see that the scope of the agreement does not make any reference in regards to a purchase obligation. And also, opposing counsel stated that in the present situation, the only fixed obligation amounted to a purchase. However, I would like to please draw the tribunal's attention to page number 13 of the record. Here, specifically on clause 9.2 on the bottom of the page, we can see that the upfront payment was in consideration of the delivery of the first batch of GORD-CAN vectors and the non-exclusive access to licensors' licensed technology. Consequently, we can see that this obligation is not entirely of a sales part. And moreover, members of the tribunal, opposing counsel stated that there was no transfer of know-how. But in the present situation, not only in clause 9.2, we can see that, but also we can see such information on clarification number 17 on page 55 of the record, if the tribunal could please follow me to that page. Here, members of the tribunal, on clarification number 17, on the 3 lines, we can see that for the production of vaccine, however, there would be necessary a transfer of know-how about the best procedures to amplify the viral vectors by using the H2K294 cells and cell growth medium. Thus, we can see that even in the purchase obligations under our contract, there is also an obligation to transfer know-how, and thus, the proponent part of an agreement is not of a sales aspect,
since only one clause in the entire agreement relates to a purchase obligation of goods and is not entirely of a sales obligation. Thus,
But counsel, the transfer of know-how, I need the transfer of know-how when I'm buying a car, when I'm buying a computer, I need a manual. So that is the transfer of know-how. Without that, I cannot make use of any goods. That would mean whenever there is a manual or the like, or some information that would no longer be a contract for the sale of goods, but rather a services contract?
Madam Presiding Arbitrator, what respondent submits is that even the purchase obligations under our contract are not entirely of a purchase nature, but also we should take into account that all other 15 clauses of our agreement refers to the granting of a license by respondent number 1 to claimant, and the parties clearly emphasized the licensing part when drafting the PCLA. Thus, we can see that according to the essentiality criterion and the party's intention, the proponent part is of a non-sales aspect. And now, moving on to the second submission, that respondent number 1 did not breach its obligation to deliver conforming goods pursuant to Article 42 of the CSG. This is true for 3 main reasons. First, a claim did not exist prior to the conclusion of the contract. Second, a frivolous claim does not amount to a violation of Article 42 of the CSG. And third, respondent number 1 could not have been aware of the existence of such claim. Members of the tribunal, a claim, according to the Secretariat commentary, is a threat of litigation. And in the present situation, Ross Pharmaceuticals never threatened to initiate any legal action against
Counsel,
claims.
you heard my question, which I asked counsel for claimant. So which law does decide whether there is a claim by Ross against claimant?
Madam Presiding Arbitrator, we are assuming that the CSG is applicable since claimant's request refers to Article 42 of the CSG. But even in the event the CSG is not applicable, then the parties could only be held liable.
Yeah, but the CSG would be applicable for the relationship between claimant and respondent, yeah, under the contract. But which law governs the relationship between Ross and claimant?
Madam Presiding Arbitrator, there is no contractor relationship between claimant and Ross.
Okay, that would be a tort claim, probably.
I apologize, Madam Presiding Arbitrator. Could you please?
Would be a tort claim, probably, not a contractual claim. I agree. Yeah.
Yes, Madam Presiding Arbitrator. But in the present situation, members of the tribunal, I see that my time is elapsing. May I please ask this tribunal for 2 extra minutes to briefly conclude my submissions?
Yes, please, granted.
Thank you, Madam Presiding Arbitrator. In the present situation, Ross Pharmaceuticals never threatened to initiate any legal action against claimant, and claimant's use of the Goritkin vectors is perfectly undisturbed. I would like to please draw the submitter's attention to page 35 of the record. Here, we can see an email that was sent from Ross Pharmaceuticals to an employee of respondent number 2. And this email consists in the basis of claimant's entire concern. However, on the 3rd paragraph, which starts with, "in my view," it is stated, and I quote, that it is the interest of both parties to solve the divergence in interpretation in an amicable way outside of courts. And hence, members of the tribunal, Ross Pharmaceuticals has demonstrated their willingness in resolving the dispute by not initiating a legal action against claimant. Thus, a claim did not exist prior to the conclusion of the contract. Also, contrary to opposing counsel's submissions, a frivolous claim does not amount to a violation of Article 42 of the CSG. According to the Secretariat commentary, which is the closest counterpart to an official commentary of the CSG that we have. It is stated, and I quote, that this article does not mean that the seller is liable for a breach of his contract with the buyer every time a third person makes a frivolous claim in respect of the goods. And members of the tribunal, in the present situation, Ross's license is clearly limited to malaria and other related diseases, and Ross Pharmaceuticals only mentioned cholera as a related disease to malaria, and these two diseases attack mainly the digestive system, while the COVID-19 attacks mainly the respiratory system, and thus Ross's claim is completely unfounded. And if I can be of no further assistance to this tribunal, this concludes the submissions, namely that.
Thank you very much, counsel. I ask my two co-arbitrators, any questions for counsel for respondent, please?
Yes, please. I would like. When you were referring to the contract, you emphasized the fact that the contract was very much focused on the license part, right, on the licensing. But then claimants asserted that the fact that the viral vectors were not being delivered, if that was the case, if they were not being purchased, then the whole purpose of the contract couldn't be achieved as a whole. So by not having the viral vectors, by not purchasing the viral vectors, then the whole purpose of developing the vaccines wouldn't be achieved. Could you please elaborate a little bit more on that, as you focused mostly on the licensing? Could you please elaborate what would be the effect or the impact in the overall contract, in the overall objective of the contract, if those batches of the viral vectors were not purchased?
Members of the tribunal, I apologize. I had an internet connection problem. I couldn't hear what this tribunal stated. I apologize.
Okay, so I guess it's me again. Sorry. So I'm gonna leave it like this then.
I'm not sure I could understand you, Claudia. So I think it was rather the problem on counsel for respondent side. So maybe you repeat your question.
Sure. Yes. I was just mentioning that respondents focused very much on the licensing part of the agreement, and claimants before stated that the overall purpose or objective of the contract would be severely impacted and could not be reached if the viral vectors had not been purchased. So I would like to ask respondents, in their view, what would be the impact in the overall contract, in the objective of the overall contract, if the viral vectors were not part of it, and if those viral vectors were not purchased, how the contract and the aim of the contract would be impacted.
Madam Arbitrator, we do acknowledge that the sale of the first batch of the Gordian viral vectors was necessary for the research conducted by claimant. However, the license, the authorization to replicate these viral vectors and conduct the research for further production of a vaccine was also important. And without these IP rights transferred by respondent to claimant, the research would lose its purposes and claimant would not achieve its final goal of manufacturing a vaccine.
Thank you very much, counsel. Any further questions?
I had one quick question. In considering the scope of the license, you characterize COVID-19 as a respiratory illness. And can you elaborate on the fact that other complications aside from respiratory complications are being discovered, and how that would affect your argument?
Madam Arbitrator, the license granted to claimant is limited for the research with the Gordian viral vectors for respiratory purposes. And in the present situation, the license previously granted in 2014 to Ross Pharmaceuticals is limited to malaria and other related diseases, but respiratory diseases are not related to malaria in any way, since not only the ways of transmission is different,
since malaria is transmitted by a parasite and respiratory diseases are transmitted by viruses, but also the symptoms are fairly different, as for example, malaria attacks mainly the digestive system, while respiratory diseases attacks the respiratory systems, and thus Ross's agreement does not cover the license that was granted to claimant. I hope this answers the tribunal's concerns.
Thank you very much, counsel. Further question, clarifying question?
Yeah, a quick one. Thank you. Respondents made reference to that email dated 6 December 2018. And in that email, I would like to understand if by quoting that part of the email, which says that Ross Pharmaceuticals had an interest in an amicable solution of the case, if that implies that there is no claim in terms of how claim should be interpreted for purposes of Article 42 of the CISG. If the fact that there was an intention to resolve this amicably is understood by respondents as if there was no claim in the way that claim is referred to in the CISG article.
Madam Arbitrator, the CISG does not provide any specific definition for what is considered a claim. What respondent submits is that this tribunal should rely on the definition used by the Secretariat commentary, which is that a claim consists in a threat of litigation. But in the present situation, Ross Pharmaceuticals never threatened to initiate any legal action against claimant or against respondent number 2, and thus there was no claim in the present situation. Thank you.
Thanks.
Thank you very much. Any further questions? Then we now turn to counsel for claimant. You have the possibility to rebut these arguments, please.
Thank you very much, Madam Presiding Arbitrator. Respondents argued that the preponderant part of the purchase, collaboration, and license agreement resumed to the delivery of the license. However, can we develop a vaccine strictly from such license? The answer is no. Members of the tribunal, besides that, respondents still failed to reckon a basic notion of commercial contracts. When delivering goods, the seller cannot deliver an associated possible lawsuit. Thank you very much.
Thank you very much, counsel. Counsel for respondent, anything on rebuttal?
Yes. Members of the tribunal, opposing counsel stated that the respondent acknowledged that the contract was only of a sales part. However, respondent's submission is that it is a mixed contract and do not ignore that it is a sales part. On the other hand, opposing counsel failed once again to demonstrate how the sales obligation was preponderant, since without the license granted from respondent number 1 to claimant, claimant could not be able to conduct its research and finally produce the vaccines. Thank you.
Thank you very much. Again, my question to my co-arbitrators, do you have final questions for any of the counsel?
No, Professor, thanks.
No, Professor, nothing further.
Thank you very much. And with this, I may close our hearing, and I thank all counsel for their cooperation in this hearing. And I just wanted to clarify, did you have the impression that you had an equal opportunity to present your case in this virtual hearing? Claimant?
Indeed, Madam Presiding Arbitrator, thank you.
Yes, Madam Presiding Arbitrator, because we are dealing only with legal questions and not the viral vectors.
Thank you very much. And with this, I close our hearing, and the tribunal now retreats to the breakout room. Thank you very much.
Thank you very much. I'll now move the arbitrators to the breakout room. I ask the teams to please stand by as we return with the final announcements. Thank you very much.
And we also ask the audience to stay, because today before we announce the winner, we also announce the best oralist who will receive a money prize given by our sponsors.
Hello, congratulations to you. You're very good. You're excellent, actually. So
Thank you. The same for you. But,
Obrigado.
thank you.
Congratulations, everyone.
You did a really good job. You should be proud.
No, you too.
You too. Are we still live? I don't know if the
Eu não
streaming
tenho
was.
Yes.
I'm not sure. But if we are,
I think so.
Oops.
Yes, yes, you are still
You are
alive.
online. You're online. We'll be online until the professors come back and announce. And first we'll announce the best speakers, and then we'll announce the winner.
So while our three arbitrators deliberate, I'd like to take this opportunity to congratulate both teams and all teams that took part in the Rio Pre Moot. It was a pleasure receiving you, albeit virtually, at Rio de Janeiro. And I would also like to thank all arbitrators, all secretary that made this Rio Pre Moot possible. A special thanks to our sponsors, our platinum sponsor, Curso Prático de Arbitragem, our gold sponsors, Galdino Coelho Advogados, Sérgio Bermude Advogados, Charter Institute of Arbitrators, CIARB, and Hughes Haber and Reed Incorporation of Saúde Advogados, and our silver sponsors, Fonseca e Salles Lima Advogados Associados, Pimentel, Vegas, Milton e Souza Advogados, e Trent Rossi Watanabe. I would just like to remember all teams that are watching our streaming right now, please stick around. Just prior to the announcement of the prevailing team, we announced the 5 best oralists. And to remember, the teams of each oralist receive an additional 600 Brazilian reais prize or equivalent. We will send an email to all awarded teams with instructions in the following week. As to the teams that passed to the elimination rounds, each team will receive 1,000 Brazilian reais. Those that went to the 3rd and 4th place, that is those that went to the semifinals, 2,000 Brazilian reais. The 2nd place, 3,000 Brazilian reais. And the 1st place, 5,000 Brazilian reais. All these amounts will be given to the teams, just to clarify, even those that are awarded for best oralists, okay? You will receive an email regarding this issue on the following week. So without further ado, we'll now wait a little bit for the return of our arbitrators. I'll pass the word back to Daniel Grunbaum, and then afterwards here, they will announce the prevailing team. Thank you very much.
Joaquin or Bernard?
I'll now call Daniel
Yeah.
Grunbaum to announce the best oralist and then pass the word back to the arbitral tribunal. Thank you very much.
Okay, thank you very much. We came to a result. We came to a conclusion.
Daniel.
Thank you, Bernard. It's a great honor to present the award for Best Oralist of the 9th Rio Pre Moot, which has been generously sponsored by Galdino and Coelho Advogados. I'd also like to congratulate all oralists that took part in the Rio Pre Moot. By deciding to take part at the moot and train so hard for it, you have risen above the average, honored your universities. I am sure you are already winners. But it gives me great pleasure also to announce the 5 oralists who have ran the extra mile. And I will begin in 5th place from the Mackenzie Presbyterian University, Lucas Nakamuni, with an average of 92 points. Congratulations. In 4th place, from the Universidade Federal do Rio de Janeiro, Manuela Mizrahi, with an average of 92.17. In 3rd place, from the Mackenzie Presbyterian University, Enrico Caparica, with an average of 92.42 points. In 2nd place, from the Pontifícia Universidade Católica de São Paulo, Stephanie Thompson, with an average of 92.78 points. And the winner of the Best Oralist Award of this 9th edition of the Rio Pre Moot is from the University of Jordan, Sima Sueda, with an average of 93.25 points. Congratulations to all oralists and to Sima Sueda for winning the Best Oralist Prize. Congratulations.
I now pass the word to Professor Schwenzer to announce our prevailing team on this 9th edition of the Rio Pre Moot. Thank you, Professor.
Thank you very much. For all who attended this final, you certainly agree with me. It was an extraordinary presentation by both teams. They were all 4 team members were very professional and were very well prepared and really astonishingly good. So we indeed had a very hard decision to take, but we have to take a decision and we have to announce a prevailing team. And in the end, it was a unanimous decision. And our decision is that the winner of the 9th Rio Pre Moot is Nova School of Law, Lisbon. Congratulations to the winner, to Nova School of Law, Lisbon, but also big congratulations to the team from Federal University of Bahia. As I said, it was very close and you gave us a hard time to decide who is the prevailing team. Thank you very much, everybody, and congratulations.
Thank you to all teams. Congratulations to all team. And once again, thank you very much to all arbitrators in the name of Professor Gabon Schwenzer, Claudia Benavides Galvis, and Hagit Muriel Elu. Thank you very much. Joaquim?
Just closing thank for the organization committee, especially Bernard. It's been very tough to handle 29 teams, 15 rounds at the same time, needing each one 45 arbitrators for 2 whole days. It's been an amazing job. Thank you, Bernard. Thank you, Daniel. Thank you, Isabel. Thank you, José Marinho. Thank you, Lucas. It's a pleasure to be part of this team, and I hope to see all of you again on the 10th version. on March 2020, hopefully in person. And I hope to see you all again in Vienna 2022. And good luck for all the teams, both in the East and the Hong Kong Pre Moot. That's just part of the journey. The Hong Kong Pre Moot starts, if I'm not mistaken, today. Then you have Vienna. So that's just a part of the journey. But you all are already winners. So good luck and see you soon.
Bye.
Thank you very much.
Thank you so
Bye-bye.
much for the opportunity.
It was a
Bye-bye.
pleasure.
Bye.
Thank you. Congratulations, everyone. Bye.
Congratulations.
Congratulations.
Congratulations.